Hey there folks, welcome to the channel's first discussion on a landmark judgment, the very famous A.K. Gopalan case. We are going to split our discussion into several videos, this being the first time that we are doing one such discussion, and the reason behind it is that I would like to spend some time defining some terms in the hope that laypersons will also be utilizing these videos. So the A.K. Gopalan case, as any lawyer and first year law student will know, is all to do with something called preventive detention. And preventive detention is what we are going to talk about in this particular video before we move on to the background of the case, the facts of the case, and the arguments that were made before the Supreme Court. So the term that we are going to hear over and over again is preventive detention. Both words in this phrase are very crucial. Each has a reason for its existence. As I have noted on this slide, preventive as opposed to punitive and detention as opposed to arrest. These words together make up a particular action taken by state apparatus, the law and order mechanism of any government, either state government or central government. And the purpose behind it is a preemptive action. It is to stop somebody from committing a future offense. This goes against the logic that we tend to give to our law and order system, isn't it? Where we investigate a crime, and if that person is found guilty of committing it, then that person is punished. Hence the term punitive in that first line on this slide. Preventive, on the other hand, is where a person is apprehended as a precautionary measure, as a preventive action. So the primary object is not to punish a person who has done something, but to intercept that person before that person does it. I am going to quote it from a judgment given by Justice C.K. Thakkar, written by Justice C.K. Thakkar in a 2008 case, which we will come to eventually, State of Maharashtra versus Bhaurao, Punjabrao, Gawande. This particular judgment, Justice Thakkar says, preventive detention is not a penalty for past activities of an individual, but is intended to preempt the person from indulging in future activities sought to be prohibited by a relevant law, and with a view to preventing him from doing harm in future. I was reading from paragraph 32 of Maharashtra versus Bhaurao, Punjabrao, Gawande, 2008. So this gives us some sort of an indication. Think of it in this manner. Should the state only act after a crime has been committed, or if there is some sort of certainty that a person is likely to commit an offense, then is there any way to stop harm being caused? It seems logical when we argue it in this manner. The problem, of course, is proving that a person was going to or would have caused some harm, caused some damage to life and limb or even property. So this kind of paradox exists in the system, and preventive detention was utilized to a great extent by the British authorities when they were ruling our country. And most of our freedom fighters, if not all of our freedom fighters, have been arrested at some time or the other under some sort of preventive detention law. The most famous example that all of us know about is at the beginning of the Quit India movement. Once Mahatma Gandhi made the announcement in August 1942, launching the Quit India movement, within a few hours, at the most within a few days, the entire leadership of the Congress had been imprisoned, had been detained, I should say, not imprisoned, based on this particular concept of preventive detention. They had not done anything, they had simply announced that they are going to launch a movement for independence, and that was sufficient for the authorities, such as they were at that time, to detain them. So detention is not arrest. Arrest usually happens when somebody has filed a complaint, an FIR, and then the police will approach that person and arrest him or her. And then of course there is a secondary one where the crime has been proved, the person has been found guilty and is convicted, and then the arrest is in order to carry out the sentence that was meted out by the court. So preventive detention does not fall in these categories. It is preventive by definition before any offense has been committed, and it is detention, not arrest. What does that mean? It signifies that the person has to be presented before a magistrate within 24 hours of detention, and further that detention can be extended only by that magistrate, and it cannot be extended beyond a total of 3 months unless there has been a further reference made to an authority which will decide whether or not the detention has to continue. Now these kind of detentions tend to happen whenever there is likelihood of rioting or communal violence or something of that sort. Every police station always maintains a list of likely and past offenders within its jurisdiction, and then that police station receives the orders to detain all those who are likely to cause some problem in the near future, whenever there is, let's say, some rally that is going to happen, some political rally or some social event or something like that. And to prevent these history cheaters or recidivists from committing any offense, they are detained preventively. Mr. A.K. Gopalan, who is the star of our first judgment discussion, was a leader of the Communist Party of India from Kerala, and he and several of his colleagues had been detained in this manner. In the next few videos, we will look at the background behind Mr. Gopalan's detention and Article 21 and 22 of the Constitution, which deal with these concepts of preventive detention as well as the right to personal liberty. So I hope you will join me then. See you. Thanks for listening.